Hey everybody, Derek Christensen here. I'm the owner of Legion Law, a premier estate planning and probate firm in Dallas, Texas. Today I wanted to talk about the 3 things that you should do in your will to make sure terrible things don't happen to you and good things do happen to you. But before I dive into that, I wanted to let you know how to reach out to me. You can find me in my email, Derek, D-E-R-E-K, at legionlawpllc.com, or you can find me in my website, www.legionlawpllc.com. So with that, let's dive right in. So these 3 things are very, very important because Texas is unique. Every state is unique in how they do their wills. Some tweak a little bit here, some tweak a little bit there. So you just want to make sure that you do what is most appropriate for Texas. If you live in Texas, you should have a Texas will. There you go. I mean, it's very that simple. But you also want to make sure that your will has these 3 things. Now, these 3 things are technically optional, but the consequences can be pretty dire as I'll dive into them. The first one is going to be that you want to make sure that your will states independent executor, at least somewhere in that document. Now, what does that mean? What I'm trying to say is that you want to make sure your will states that your executor can do whatever they want as long as they just go through probate and get approved by the judge. That is the phrase, the independent executor, or my executor can serve in an independent manner, or free of the court, something like that. You want to make sure some kind of language is in there, because if you don't, there's a very strong possibility that a court will give you dependent administration. And dependent administration in Texas, I've already made a video about this, but it is the worst form of probate ever in all of Texas. Out of the 8, it's the top. It's number 1 out of all the terrible ones. So you really do want to make sure you are not a dependent executor. You want to make sure you have an independent executor. Can't emphasize that enough. And I'll just reiterate a point. Dependent administration or executorship is going to make you get approval from a judge to do everything. You can't sell a house. You can't transfer money from bank accounts. You can't even sneeze without getting permission from a judge first. And that's going to require hearings and documents and filings and attorney's fees. And it's awful. So if you're independent, you can just do whatever you want as soon as your judge just signs off on a piece of paper and you're good to go. So you can do the house and the bank and all that stuff. So it's very, very important. Make sure you have independent executor listed on your will. The second point to make is that you want to make sure there's a self-proving affidavit for the will. This is almost always going to be the very last page of the document in which you state, hey, my second to last page, I signed it. I promise I am the testator. I promise I want this to be my will. But the last page, the self-proving affidavit is what it's called. This document will say, yes, we guarantee the person signing this document is who they say they are. And that's going to require a notary to notarize that document in addition to 2 witnesses. And you're going to want to make sure that the notary block where you say, I am the notary and I am notarizing Derek's will, you also want to include the fact that both witnesses, you're notarizing their signatures as well. So you want to say, in that signature block for the notary, again, not yours, but the notary's signature block, you want to make sure it says, I am the notary, I am testifying that Derek signed this document, and Joe Schmo and Mary Sue signed this document as well. And then when they notarize it, they're good to go. And the reason why is because you don't necessarily need this document, but without the self-proving affidavit right at the very end, you're going to have to take those witnesses and bring them into court and have them testify that you were the one who actually signed those documents. Now, oftentimes people sign a document and then 30 years later they die. So 30 years later, you're trying to find Mary Sue and, you can't find her because she might be dead or she might be in California or whatever, right? And if you can't find those signatures, things get bad real quick. If you can't find those witnesses to testify on your behalf, things get bad real quick. So either way, just prevent it from everybody. Nobody wants to get dragged into court, especially your witnesses who are already doing you a favor. So just do them a favor and get that self-proving affidavit. The last thing that you want to do out of the 3 is you want to make sure that you list your children on the will. So what does that mean? And why? Because can't you just list them as child A, B, and C in the bequest section? Because the bequest section is going to be the one that determines who gets what percentage of everything, or who gets this specific knick-knack or whatever. But you want to list them at the very beginning, and then the bequest section can reflect the same names, or they can be different, actually. And it's really important to emphasize you can give all of your stuff to one child instead of three. You can give it in piecemeal. You can give it different percentages. And at the end of the day, if you don't list every single child, there is a possibility that somebody could come in and say, oh, well, A, B, and C are mentioned in the bequests, but I'm not, and I'm child D. I promise. And then everybody gets real riled up real quick because the judge thinks you're lying to them. You got to hire an extra attorney to investigate the family tree. You change probate entirely, and now it's more expensive and drawn out. It just gets messy really, really quick. So if you list all of your children right from the get-go and you say, these are all the children I have at the time of making this will, I'm going to include also any child born after me signing this will. If you say that, then you'll very clearly state, these are my children, no one else can come in and claim that they are, and you'll also make it very clear that you're disinheriting somebody on purpose in the later section if you don't include that person, or if you don't include that child. So if you say A, B, C, and D are my children, and A and B are the only ones mentioned in the bequest section, then the judge knows, you know you have children, you know you're purposefully ignoring them and not having them have anything. So that's very, very important, especially for those who are trying to disinherit their children or not inherit or give any inheritance to their children. So either way, those are the three things. Make sure you list independent executor. Make sure you mention that, or make sure you have a self-proving affidavit at the very end, and make sure you list all of your children that you have, even if it's not with your spouse or with someone else. So with that, if you guys have any other questions about the specifics that you should include in a will, especially in Texas, I'd be more than happy to help out. I'm always a resource, and you can email me directly with any question, Derek, D-E-R-E-K, at legionlawpllc.com, or you can find me at my website, www.legionlawpllc.com. You can go to our Contact Us page and schedule a free consultation over the phone directly onto my calendar at that website. So thank you so much for watching, and have a great day.